This week has been full of decision-making for President Bola Tinubu, from the suspension of Halima Sheu, who is the National Coordinator and Chief Executive of the National Social Investment Program Agency, that's the NSIPA, to the suspension of Minister of Humanitarian Affairs, Betta Edu, on fraud allegations, the slashing of expenditure on domestic and foreign travels by 60%. President Tinubu also suspended the NPower school feeding and other social investment programs this week. But the biggest story of all is the Supreme Court decision to affirm 8 governors whose seats were challenged. Welcome to Standpoint. I am Precious Amayo. Now let's get to our conversation. There were celebrations across 8 states yesterday after the Supreme Court delivered its verdict on the governorship tussles in Kano, Plateau, Zamfara, Lagos, Bauchi, Abia, Ebonyi, and Cross River. The winning and losing political parties and the candidates involved in the governorship contest have in turn reacted to the judgments, either affirming their victories or dismissing their petitions. The Supreme Court judgments have, however, raised new posers as it reversed appeal court rulings that had sacked governors over the processes that led to their emergence as candidates. Now, joining me to talk about this, 2 lawyers. We have Liborous Oshoma joining us in the studio. I understand that Nibe Effiong will join us on Zoom. When he does, we'll have a conversation with him. But let's talk to Liborous Oshoma. Good to have you in the studio. I've always spoken to you on Zoom, so good to have you here. Let's talk about this because it is raising a lot of questions as to, the implication of this. I will get to that shortly. But what do you make of the Supreme Court judgment? All 8 governors affirmed, petitions dismissed.
Apart from Plateau and Kano, and Zamfara, all other petitions, everybody knew where they were going to fall anyway. But for Kano, if you remember, Kano and Zamfara, a lot of lawyers also were divided on the position of the Court of Appeal, and that those positions were alien to the provisions of the Electoral Act, and especially for that of Kano, considering Section 63 of the Electoral Act. And also the question raised, which Supreme Court finally laid to rest yesterday, was as to at what point did the witnesses speak to those ballot papers or was it just that the tribunal sat down in the comfort of their chambers and started expunging or deducting votes on the ground that those ballot papers were not, stamped and signed, considering the provisions of Section 63 of the Electoral Act. And the Supreme Court answered all of that yesterday to say, well, even the ballot papers were stamped, though not signed. And if you look, permit me quickly, Section 63, so for the benefit of our viewers, Section 63 talks about rejection of ballot papers without official mark. But it says Section 63(1) says, subject to subsection 2, a ballot paper which does not bear official mark prescribed by the Commission shall not be counted. But there is a proviso. Subsection 2 says, if the returning officer is satisfied that a ballot paper which does not bear the official mark was from a booklet, was from a book of ballot paper which was furnished to the presiding officer of the polling unit in which the vote was cast for use at the election in question, he or she shall, notwithstanding the absence of the official mark, count that ballot paper.
So as long as the returning officer decides that, look, this is valid,
as long as the returning officer identifies that this ballot paper, though not marked, it's from the booklet, because the booklet are usually serialized. So what they look out for are the serial numbers of those ballot papers. And so even if it is not marked, because, mind you, these ballot papers are stamped in their office manually before they are taken to the feed. And so in the course of doing that, the law
also makes space for human error.
Yes, the law also identified that there might be human error. And so now invalidating, despite this provision, invalidating a governorship election on that ground alone, and then the ground that the Court of Appeal, sitting as election petition tribunal, presidential election petition tribunal, had laid to rest on issue of membership of political party. The Court of Appeal laid that to rest, the same Court of Appeal. So I was taken aback when the Court of Appeal in Abuja, sitting on the election petition in Kano, heard that the governorship candidate of MPP was not a member of the NPP as at the time he joined, even though a court of coordinate jurisdiction has ruled otherwise, that it was purely an internal affair of the party. So that's, we know, some of us know that Supreme Court certainly was going to reverse that. But you see, like Nigerians, thanks to social media, now you have more lawyers on social medias than you have actually practicing. So a lot of people gave APC, too much credit, much more than they have. Oh, APC would, they would decide. Even till now, some people are saying, oh, it was because of the number of you they saw in Kano. That was why the judges of the Supreme Court had to, do a retake. But I doubt, because the law does not work that way. But it is easy for people on social media to say, oh, it is because of the fear of what would have happened in Kano. No, that's not it. It is the position of the law.
So these issues were clear from day one.
Clear ab initio. The only area, like I talked about, I talked about Plateau. Plateau, if you look at what happened in Plateau, and you also marry it with what had happened in Zamfara in 2019 and in Rivers in 2019, yes. There's a thin line between what happened in Plateau and what happened in Zamfara. In Zamfara, there was INEC guidelines and timetable that was released that parties must comply with. And a failure to comply or to meet that deadline was fatal to feeding of candidate. And that the what do you call it, APC in Zamfara then, because of the internal crisis in the party, did not meet that deadline. And so INEC rejected their candidates, that this candidate can no longer come in because they were, those names were sent to INEC outside the prescribed time. And they went as far as the Supreme Court, and the Supreme Court said, no, well, its failure to meet these guidelines is fatal. And that also was what happened, conduct of congresses. That was also what happened in Rivers State. Court had made pronouncement. But in Plateau, there's a very thin line. In Plateau, the distinction is the fact that the court had ruled that the primaries conducted by the PDP, the court had nullified the primaries conducted by the PDP and asked them to go conduct another congresses. And that was why the Court of Appeal heard in the local government election conducted that they do not have the right to feed candidates. But while that was on, subsequently, it was, I think there's information that they conducted a subsequent primaries in some states, in some local government, not all, I think 12 local government. And so it was on that basis that the Supreme Court heard that being an internal affair, a matter of the party, and having taken step to remedy the wrong that the court complained of, you can no longer punish them for that act. But the problem here is the fact that some persons had suffered injustice on the basis of that interpretation. Those members of the House of Assembly,
yes, and National Assembly, and I'm going to get there in just a moment, because it's been a conversation where, the National Assembly can only get to the Court of Appeal, and so that's where they can't get to the Supreme Court for proper interpretation. That
used to be the fate of governors also. Some governors will be removed on wrong interpretation, while some will stay on the same set of facts. And so it was as a result of all of this conflicting judgment that the Supreme Court, in its wisdom, requested for an amendment to the Electoral Act and the Constitution to allow for governorship election petition matters to terminate at the Supreme Court. But with what we are saying also now, this conflicting interpretation at the lower court.
When you check Plateau, sorry to interrupt you, the PDP, almost everyone who won on that platform for the National Assembly were removed.
Yes.
And so, but that is the same interpretation that has now favored the governor.
Yeah.
And so should that be reviewed for the National Assembly as well?
The matter had, apart from the fact, like the Supreme Court said yesterday, time for determining those matters had lapsed. The law, the position of the law is that for election at that level, the final court is at the Court of Appeal. And so there is nothing anybody can do about.
Should that not also be, I mean, that's why can we not have a constitutional review?
That's why I'm saying that, except we want to further burden the Supreme Court, because now, as we speak, the everyday matters at the Supreme Court have taken a back seat. You have the Supreme Court giving you 4 years adjournment, 3 years adjournment, 2 years adjournment for ordinary civil and criminal matters. So electoral matters now take, both pre-election, post-election, take the top burner because they are time-bound. If you now decide also to elevate all cases to the Supreme Court is going to be weighed down. What we certainly will just have will just be the Supreme Court creating a panel that will deal strictly with electoral matters. And you saw what the Court of Appeal had to go through, determine governorship election petition from all of the states, House of Assembly, House of Rep, Senate, and all of that. So
but
I think the end to all of this quickly, if INEC can elevate their modus operandi and be able to bridge the gap between the trust deficit that people have and the elections are transparent enough.
But will politicians not be politicians? Politicians are always looking for ways to upturn elections and ensure that they get there. If it's not true, the ballot, then they want to use the court. But I was trying to mention, I can't remember which of the judges, appeal court judge, the Supreme Court was talking about yesterday. If it's in the Kano or Plateau state, where I think that same judge has now been elevated to the Supreme Court level. I'm trying to get it right. And they were talking about the particular judge in the appeal court, and they really were, very upset about the judgment he gave. And so
does that a lot most times.
That's why one is wondering if shouldn't there be another option for those who are in the national.
And that's why at the Election Petition Tribunal level you have 3 judges. At the Court of Appeal level you have 3 judges who also have passed through the High Court and they've been elevated. At the Supreme Court level you have 5 judges. And who also had passed through the Court of Appeal. So experience at this stage really counts. But like you have said, most times higher courts have had strong words for lower court when there's a miscarriage of justice. Like was it Justice Agim or Justice Okoroye said yesterday of Kano, that the findings have no place in the Electoral Act, and they were just mere sentiment and opinion expressed by the judge. And because the Electoral Act was clear on the issue of ballot papers and the issue of membership of political party. And the Supreme Court also had interpreted that position in the case of Labour Party and INEC when the, APC filed a counter petition contesting the candidature of Peter Obi, having not joined, by virtue of Section 77 of the Electoral Act, having not joined the political party 30 days before the conduct of primaries, that his name is not on the register. It was on the same ground that the courts of appeal nullified the election in Kano. And the Supreme Court came down heavily on those judges. And were like, this has no place in law. It's a mere sentiment. And the issue now for Plateau is clearly there's a miscarriage of justice, as regards those House of Assembly members and those House of National Assembly members. How can they be remedied? The law is silent. The law, like we said, there should be an end to litigation. The only way you can remedy such situations is to have some of these cases determined by Supreme Court before the Court of Appeal would decide those cases. You remember what happened in the case of Ndudi Elumelu in Delta State. Ndudi Elumelu had gotten judgment at the tribunal. The main ground was that issue of Section 77, that the candidate of Labour Party his name was not on the register of members of the political party. The moment the Court of Appeal, sitting as the Presidential Election Petition Tribunal, ruled that had no place in the electoral jurisprudence, the matter, everybody knew that Ndudi Elumelu was going to, he was going to lose the matter at the Court of Appeal. And so the Court of Appeal, the moment that matter got to the Court of Appeal in Delta State, the court simply, allowed the appeal, and that was the end of political end for that time of Elumelu's candidature. So I think that going forward, instead of saying, let all matters go to Supreme Court, it will overburden the Supreme Court. Now we're even talking about decentralizing the Supreme Court. What should happen is allow the Supreme Court to determine most of these matters, and then the lower courts can follow in as far as electoral matters are concerned. But another thing which is very instructive...
I want to, and I will let you get...
Sorry, another thing that's very instructive is the type and the knowledge of judges that we elevate to these places is very key. It must be said, Because when you read all of this judgment, you listen to the Supreme Court yesterday and you read some of the judgments.
But what is the criteria for elevating judges?
Yes, apart from appointment of judges, 10 years, and then also the criteria for elevation, you must have served as a high court, judge for a number of years, and then you pass through a screening process. But I want to draw your attention to the former NBA chairman who is contesting for governorship, NBA president. When some judges that were to be elevated to the Court of Appeal were screened, and he raised an alarm and said that some of the judges could not even pass the test, and so he wondered how they would be elevated to the Court of Appeal. So if at that level, lawyers are already saying, look, these judges are not, qualified enough to determine matters at that level, I think there's need for us to really, take a second look at the kind of people we send to the bench. Because when you look at some of the judgment, when you read through some of the judgment and then you read, the appellate judgment and what the judges are saying, you now begin to wonder, is it a different law that these lower court judges were reading, or they just wanted to be mischievous? And
I think you already started touching on the question I was going to ask you earlier, because some of these, over and over again, some of these issues, especially around nominations, primary, the Supreme Court has always said, look, they are pre-election matters. And if they're not resolved at that level, then that's it. And they also, when you the issues also, that you can only be challenged by, and these issues can only be challenged by someone who is a member of that party. Because in some cases, what we see that the other people who are challenging nomination of someone are not members of the party, and did not even participate in the primaries themselves. So the fact that the appeal court nullifies the election of a governor based on a pre-election matter from a person who is not a member of the party and did not participate in nominations, what does that say to you? You
see, this law changes, with time. If you remember, by 2003, we had the Electoral Act amended in 2002. 2007 election, we had the Electoral Act amended in 2006, just like that until 2010. So at every turn, some sections are amended. Before now, even if you are not a member of the political party, you could challenge the candidature of a candidate, even at the tribunal. It was an issue. Even if you are not a member of the political party, you could go to court you could approach the Federal High Court and challenge the candidature of a political party. That was why the case of Bayelsa, it was the PDP that challenged the candidature of Degi Eremia. But the Electoral Act was subsequently amended to the fact that if you are not a member of the party, if you did not even participate in the primaries, you cannot approach the court to challenge the outcome of the primaries. Not to now talk about waiting to challenge, even though one of the grounds for challenging an election is the fact that the candidate was not validly nominated. But the court had ruled that by virtue of that provision, you can no longer challenge the candidature of a party at the tribunal. It's a pre-election matter, and you are not even a member of the political party or participated in the process. So there's no contrary decision of the court on that. So that's a novel decision by virtue of the amendment in 2022. So I think some courts also, you have to be abreast with this, because we say law is dynamic. You have to abreast with these things as they come for you to truly understand the import. And so some of this court, that's why I also talk about the people, the judges. I've had cause to be at the tribunal panel of 3, and it's only one that is working. The rest are just either nay or eyes. So it is only one. Most times it is one that takes record. But you could see that interaction among them. But there are some, they'll say, okay, you see only 2 sit for most part of the time. They'll say one had them, maybe it's indisposed. So the quality of judges that we send to these places also matters. And how well are they abreast with the current position of the law. And most of these things, as soon as they come, as soon as the law is amended and the matters, typical politicians, like you have said, they always approach the courts. And so you find out that if you dig further, the Supreme Court would have made a declaration on such section. And so it becomes very easy for every other court to follow. But also, I will not sit down here to exonerate judges to say, oh, no, look, they are not being mischievous. Some can be mischievous. They'll say, well, anyway, we know the Supreme Court will overrule us, but let us just give you judgment for the sake of giving you judgment. So when you get to Supreme Court, you guys will go and battle it out. It happens because what are the rudiments or the standards set for discipline, judges when some of these things happen? Nothing. And you can give a wrong judgment based on your perception. Like we say, it is the
subject to interpretation.
Exactly. So how do you punish a man who
for his
is
own,
not looking at
his own interpretation?
Exactly. So those are the issues. So when that happens, it becomes very difficult for you to do anything about it. You can always say, well, maybe the way the argument presented by the lawyers also.
And the evidence before the judge.
But it's the same evidence that the superior court, evaluated and now gave a different opinion.
But what about the legal advisors of these political parties? It seems as though whether they are not doing their due diligence or not, especially through the screening and nomination processes, and then through the litigation process, when you see that, look, you should be able to advise your party to say, in this nomination process, there is a challenge here. If we go through this, we might be, this election might be upturned, it can't even win, or there is a problem with this litigation, this cannot hold. What does that say about legal advisors of political parties? You
find out that legal advisors, most times for political parties, apart from the major political parties, even in some cases, they are compensatory. So, and imagine a President Olusegun Obasanjo, appointing advisors and saying, I'm not bound to listen to your advice. So in one breath, you can have legal advisors and they will give you the best of advice. And you say, I'm not bound by it. After all, I am the head here. So the buck stops at my table. And in the same way, you can have advisors who are compensatory, who know nothing about the entire process. And they just say, Jones, okay. And so until you get to court, that's where you now find out that, the decisions that you took. And then also the attitude of the politicians itself. You find out the politicians will always, like Eleke the bird in Chinua Achebe's Things Fall Apart, always look for a way to bypass the process. We have situations where politicians will, like what Wike calls Ihendeba. You have one leg here, you have one leg here. Somebody is a sitting House of Assembly member, is a speaker. He has not resigned on the floor of the House, but yet he's contesting election in another party as a governor. We had it in this 2023 election, but these issues are not brought to the fore. So when all of this begins to happen, how do you advise such a man over his ambition? He tells you he wants to be a governor. And you say, no, what you're doing is ultraviolate the rule. He said, don't worry, we'll have a way. You are not the politicians. We'll have a way around these things. At the end of the day, it is only the court. And in some cases, and that's why do you think the Court of Appeal, the President Court of Appeal, kudos to her, she decided to do what she did by splitting all of the appeals into two, one in Lagos, one in Abuja. And I also learned that in some cases, the members of the panel didn't even know the cases they were going to handle until they got to court. And it is that money that they got to court, that files were handed over to them to look through. And so just to make it impossible for politicians to compromise these persons, because of the desperation of politicians, the only job in Nigeria today is politics. That's why the day you are appointed, you are given an appointment, your primary schoolmates will celebrate you. They are not just celebrating you because they believe in your capacity, but they are celebrating you because everybody will be asking you, what is in it for us? What is in it for us? So with all of that, it is not a call to serve, but a call to chop. And that's why you also have this attitude, this mentality of, do you know who I am? When you get there, you believe that the world should, crumble at your feet. And so power, like they say, corrupt, and absolute power corrupt, absolutely. So a man who has absolute power, there are no checks. You are governor, for example, the House of Assembly is an appendage of the governor's house, a situation where you can even bomb the House of Assembly and create a room for them to sit in government house, and they are answerable to you. So who is going to advise you in such circumstances? Which advice will you listen to? So these are some of the challenges that even the legal advice that they get. In some cases also, they say, oh, this man, haven't you heard of the word, he won't be loyal? or he has a mind of his own. When you have a mind of your own and you give quality advice, nobody wants to relate with you. And so they say, well, keep him in one corner. He will come now and begin to speak English and speak law. Now law will chop. You know, so get to the tribunal, see what you can do, compromise the process, compromise everybody. And that's why also, for the people, they don't have faith in INEC, they don't have faith in the judiciary. And with what had happened in the last election, people had expected that INEC was going to create a process that would be, you know, above board, similarly 80%. But unfortunately, even though at the beginning the process was going seamlessly, people were already giving INEC kudos. But INEC, by their own making, you know, disrupted the process. And eventually, even though the outcome was desirable, people didn't have faith in the process. And that's why everybody trooped to the tribunal. But with this judgment, it is obvious now that even when you go to the tribunal won't help you. So the best thing is concentrate your energy at the poll. If you do not win, like they say, you live and for God and work twice as hard for the next election, if you can.
So I've heard lawyers and analysts in recent days say something about, you know, respecting the will of the people. That, look, if a governor had or a candidate had the majority of the votes, and you see how people are responding to that particular victory of that person, you know that is the will of the people and you should respect it. But my question is, how do you then balance that respect for the will of the people with the technicalities, you know, or navigating the technicalities of the Electoral Act?
The will of the people also is subjective. When I say will of the people, celebration is subjective. You know, sometimes it is not, let me put it this way. You can have 100 people in a polling unit, and at the end of the day, 20 people decide to come past, you know, cast their vote. It is those 20 people that will determine the fate of the candidate in that polling unit.
And that's a minority when you look at 100.
When you now look at the number, the total number, it is the minority. But in some cases, that majority can decide to come out and say, we no go agree, or we want to celebrate. You now think they are in the majority. Meanwhile, in actual sense, when it comes to the ballot, they are in the minority because they did not register to vote and they did not participate in the process. So that's why I said the will of the people and the celebration are subjective. But in the case of, you know, the legislature, the judiciary and the Electoral Act, and then vis-a-vis the ballot, you find out that with every amendment, the legislature tries to limit the interference of the judiciary in the outcome of the process. Even though yesterday, I described yesterday as the real election day for those states. That was the real election because the fear among the politicians, what if the court says otherwise? Election held more than 10 months ago, but the people, the candidates are still waiting. In some states, you know, activities are at a pause, waiting for the courts to determine. It shouldn't be so. And that's why you find out that courts, in most cases, like the Supreme Court has said yesterday, they try to restrain themselves from interfering in the will, the general will of the people, as laid down by the provisions of the law. And those where most times they now tell you, these are internal affairs of the party. Let the party deal with it. It's not for us to sit down here as a court, a panel of 5, to begin to determine who is a candidate and who is not a candidate. When the party has said, this is our candidate, this is their discretion. So if you are a member of the party as at that level and at that instance, you now approach the court to say the procedures laid down in the party guideline were not followed. It's a different matter altogether. Not after the election. You now come, you're not contesting the outcome, the balloting, the votes. You are saying the procedure that produced this candidate, you know, you have a problem with it. The court will say, no, well, that's an internal arrangement of the party. All of that should have been dealt with before the determination of the general will of the people. So you find out that the court gradually now are restraining themselves from interfering. But that does not stop the fear of the people because of the attitude of politicians. Also, that has not stopped the fear of the people because the umpire, INEC, had not also lived above board to truly show that they want to be an umpire. This same political party that is in government today, APC, some of them, majority of them, where they were in opposition, they knew how to conduct credible election. Uwe's panel report was touted as the best thing that could happen to Nigeria. But today, nobody is discussing Uwe's panel report.
It's not been implemented.
But nobody is discussing appointment of the INEC chairman and the resident electoral commissioners. How wreck election. So until we go back to those recommendations that we can take, that they themselves also knew or felt were germane to having a transparent process. Yes, the beavers, the IREV, fantastic technology, but this thing are manned by people. Apart from Mike Igini in the last dispensation, who showed strength, courage, you know, in the conduct of election, even having to prosecute a returning officer, Professor Peter Ogban. Which other electoral officer did that? None. So INEC needs to consistently, you know, even though the court has said, well, INEC did, you know, to a large extent well, but the people that participated in the process are saying, look, the challenges you have ought not to have happened in the first place.
All right, so let me ask you, because we're preparing for the Edo and Ondo elections. Again, what is the big takeaway for you in these judgments, and then what's the implication for these elections, some of these judgments for these elections, you know, coming up?
Yeah, you remember it was this same Edo and Ondo that INEC used as a test run to win the confidence of the people that they could conduct credible election. Remember in Edo, even the candidate that lost the election said he wasn't going to go to court, that it was a waste of time, because that was when they started to introduce this IREV, and people abroad could monitor the result as they were being uploaded. And once that happened also, like I had said earlier, once that happens, you find that the floodgates of litigation at the tribunal will reduce. And the process, the believability in the process also will increase. And so for Edo and Ondo, one off-cycle election, that's, for me, off-cycle election has never been a determinant for determining, you know, an election to determine, you know, the performance of INEC, because INEC would deploy everybody, every tool available to them across the states to that state where election is holding. And at the end of the day, we say, oh, kudos to INEC, you know, they did so well, materials got to where they should get to at the appropriate time. The last election that happened in Bayelsa, what do you call it, Imo and Kogi, you know, even though that of Imo, we all know what happened. Even before the election, a lot of people said, look, those that will be allowed to vote, that was purely not INEC fault. The politicians knew what happened. For Bayelsa, you saw it was neck to neck. You know, it was, if the presidential election had gone that way, even the losers would have said, well, we gave it our best word, but we know that next time we need to go back and prepare. But that wasn't so. So I want to see a repeat of that. Allow a level playing field. Let the materials get to where they should be at the appropriate time. And let your technology, you know, be top notch. Even technology, what do you call it, providers. When they innovate new technology, they employ hackers to test, you know, the potency or the strength of those technology. Is INEC doing that now? So we don't come back tomorrow and
INEC has a few months, because it's September.
Yeah.
Few months to put its house in order and prove itself again.
Yeah,
in these two elections. We'll see how it plays out. Thank you so much for your time as always. We're supposed to have Inibe Efiong, he couldn't join in, but Liborous Oshoma did justice to this conversation. Thank you for talking to us.
Always my pleasure.
All right, let's take a break now. When we return, Edo election, we just already mentioned that, is in September. We'll be having that conversation in just a moment. Stay with us.